Hello, this is R.J. Deacon, reading the Supreme Court of the United States opinion syllabus in Upper Skagit Indian Tribe versus Lundgren, certiorari to the Supreme Court of Washington. Argued March 21st, 2018. Decided May 21st, 2018. The Upper Skagit Indian Tribe purchased a roughly 40-acre plot of land and then commissioned a boundary survey. The survey convinced the tribe that about an acre of its land lay on the other side of a boundary fence between its land and land owned by Charlene and Ray Lundgren. The Lundgrens filed a quiet title action in Washington State Court, invoking the doctrines of adverse possession and mutual acquiescence, but the tribe asserted sovereign immunity from the suit. Ultimately, the state Supreme Court rejected the tribe's immunity claim and ruled for the Lundgrens, reasoning that, under County of Yakima versus Confederated Tribes and Bands of Yakima Nation, tribal sovereign immunity does not apply to in rem suits. The Supreme Court held, Yakima addressed not the scope of tribal sovereign immunity, but a question of statutory interpretation of the Indian General Allotment Act of 1887. That act authorized the President to allot parcels of reservation land to individual tribal members and directed the United States eventually to issue fee patents to the allottees as private individuals. In 1934, Congress reversed course, but made no attempt to withdraw lands already conveyed. As a result, Indian reservations sometimes contain both trust land held by the United States and fee patent land held by private parties. Yakima concerned the tax consequences of this intermixture. The court had previously held that Section Mark 6 of the General Allotment Act could no longer be read as allowing states to impose in personam taxes on transactions between Indians on fee-patented land within a reservation. Moe versus Confederated Salish and Kootenai Tribes of Flathead Reservation. The court reached a different conclusion in Yakima with respect to in rem state taxes, holding that the state collection of property tax on fee-patented land within reservations was still allowed on Section Mark 6, 502, U.S. at 265. In short, Yakima sought only to interpret a relic of statute in light of distinguishable precedent. It resolved nothing about the law of sovereign immunity. Acknowledging this, the Lundgrens now asked the court to affirm on an alternative common law ground that the tribe cannot assert sovereign immunity because this suit relates to immovable property located in Washington state, purchased by the tribe in the same manner as a private individual. Because this alternative argument did not emerge until late in this case, the Washington State Supreme Court should address it in the first instance. The decision is vacated and remanded. Justice Gorsuch delivered the opinion of the court, in which Chief Justice Roberts and Justices Kennedy, Ginsburg, Breyer, Sotomayor, and Kagan joined. Chief Justice Roberts filed a concurring opinion, in which Justices Kennedy, or just Justice Kennedy, joined. Justice Thomas filed a dissenting opinion, in which Justice Alito joined. Thank you for listening.